we had the enactment of the Freedmen's Bureau Act. And both these laws were premised on Congress's authority granted by the 13th Amendment, that is, the power to eradicate slavery as well as involuntary servitude. Okay? But then there were some doubts. There was a fear that if we only relied on the 13th Amendment, that these new civil rights laws would not be valid, that the Supreme Court may actually declare these laws unconstitutional. As a result, the members of Congress decided that they needed to try something else. They wanted to solidify the protection of these sorts of rights. That led to the ratification of the 14th Amendment. Right? The 14th Amendment had a lot of things. It granted citizenship to the freedmen. It ensured that states cannot violate their privileges and immunities. It ensured that the states cannot deprive people of their life, liberty, or property unless they're given the due process of law. It required the states to protect equally, that is, provide equal protection to all people in their jurisdiction. And then most importantly, Section 5 of the 14th Amendment gave Congress the power to enforce those rights, that if the states were violating those rights, Congress could intervene. So this was basically a roadmap, if you will, to the protection of various rights by the Reconstruction Congress. Now, it wasn't even clear what role the courts would play in this, right? The primary vehicle was Congress to enact these civil rights laws, which would be enforced in the courts. But the very first cases that came to the Supreme Court involving the 14th Amendment had nothing to do with race, at least not directly. The first case we had was Slaughterhouse, which involved, not a trivial issue, but it wasn't a weighty issue. The case involved the right of butchers in New Orleans to pursue their trade, to have their own butcher shop. And they challenged a sanitation law. And the court said, well, the 14th Amendment doesn't really protect the right to earn a trade. It doesn't protect any sorts of fundamental rights. It only protects, certain national federal rights, like accessing the government. And the very next day, we got the Bradwell case, right? That case involved the right of a female attorney who wanted to be admitted to the bar. And the court said, no. Practicing the legal profession is not a privilege or immunity of federal citizenship. Okay. Yep. But then, look, we got to the third case. And the third case took a very different direction, right? The third case was cruikshank. Cruikshank wasn't considering if there was some sort of unenumerated, unwritten right to pursue a trade. Cruikshank involved rights that were actually written down in the first 8 amendments. Cruikshank involved the right to peacefully assemble, and Cruikshank involved the right to bear arms, keep and bear arms, the Second Amendment. And the court said, no. Privileges or immunities doesn't protect unenumerated rights. It also doesn't protect enumerated rights, that is, rights that are written down. Okay? As a result, the Privileges or Immunities Clause was basically gutted from the Constitution. It was basically deleted, if you want to think of it that way, like, take white out and just get rid of it. But those decisions left a few other provisions in play, specifically the Due Process Clause of the 14th Amendment and the Equal Protection Clause of the 14th Amendment. And the cases we're going to study today focus on those other provisions, Due Process Clause and Equal Protection Clause. Okay? We have a bit of a mixed bag, right, the cases today. We have some cases you might like Strauder and maybe Yick Wo. And you have some other cases that you probably aren't very fond of, which are civil rights cases and Plessy. And invariably, some student asks me, Josh, how do you reconcile these cases? How do you put these together? I'm going to do my best to explain it, but I'm not going to make you happy. It happens every year. But Josh, how do you go from Yick Wo to Plessy in a couple of years? I hear you. I'll do my best to try to explain it. All right. But let's start with the first case, which is not actually in your book yet. It will be in the next edition. Randy didn't have Strauder in his in the case book, and I was kind of annoyed at that. I think it's an important case. In fact, most case books don't include Strauder. It's sort of this like really old case that I think is important. I don't know, maybe I don't know. What do I know about selecting cases, right? Making lists, what do I know? But it wasn't in there, so I asked Randy to add it as a supplement, and I gave you guys a PDF. So I hope you read it, because it's an important case. Let's start off with a poll question. This one's true or false? Let me start the thing. I'm sorry. ConLaw. New interface. It was easier before. They changed the way this thing works. It's annoying. Okay, there we go. All right. Strauder held that West Virginia's jury selection law violated the Equal Protection Clause of the 14th Amendment. True or false? Okay, another 10 seconds. Okay, 5 more seconds. I'll cut it off. Okay, stop it right there. Okay, who am I up to? Who's next? Nancy. Okay, thank you so much. I appreciate it. Nancy, let me ask you a question, right? Generally, with cases we've done so far, right, how do the cases make it to the Supreme Court? What are generally the types of cases we consider? Like generally, when the Supreme Court considers whether law is constitutional, how does the case get to the Supreme Court? And this is a little bit of a tough question, but I'm going to try and tease it out.
Like it goes to the trial court and then to the state Supreme Court?
Okay, good. So it starts in a trial court, but usually, who's challenging the law? Is this a case where someone just decides they don't like the law? How do cases usually get to the Supreme Court? Think of a case we've done before.
When they want to argue, like if they have the constitutional right or if it's been violated.
Right. Okay, good. So think of like the slaughterhouse cases, right? Who are the plaintiffs in that case?
The butchers.
Okay, very good. In most cases we do, there's a plaintiff, right? There's someone who goes to court and says, I think this law is unconstitutional, right? The butchers in New Orleans said that we think this sanitation law is unconstitutional. Myra Bradwell, the lawyer from Illinois, said, I think the Illinois Supreme Court's actions are unconstitutional, right? But there are other kind of cases. Is this Jamie or Ben? Ben. How did Cruikshank get to court? How did the Cruikshank case get to court? All of last week. What was Cruikshank about?
There's the massacre.
That's right. Right. There was a Colfax massacre. That's right. And then what happened to those who murdered the people, who lynched the people?
Were they indicted for murder?
They were they were indicted for murder. Close, really close.
Murder.
No, they were not charged with murder. What were they charged with?
I can't remember.
I said it 5 minutes ago. Nick?
Violating rights of the people they murdered.
Okay, which rights?
14th Amendment rights.
Are you guessing? You seem very uncertain.
Yeah.
Well, you made some good guesses, so I'm going to try and pin you down even more.
Okay.
What kind of statute were they accused of violating?
I guess just discrimination based on their race.
Yeah, you're guessing enough. It's fine. You guessed your way pretty much for the right answer. They were charged with violating the Civil Rights Act, which protected the privileges and immunities protected by the 14th Amendment. Okay? So that was a different case, right? It wasn't that Mr. Cruikshank went to court. He was being charged with a crime. And he raised as a defense that the federal law was unconstitutional. Right? But Strauder's different, right? Jonathan, What was Strauder charged with?
Murdering his wife.
Murdering his wife. Gruesome story. Gruesome. I mean, just I pulled up some of the old newspaper clippings. He like bashed her over the head with this blunt object. It was pretty gross, right? It was a pretty gruesome murder. Was there any doubt that the state murder law was valid? Okay. What then was his grievance? It wasn't with the state murder law.
It had to do with jury selection.
Okay. How was the jury selected?
It was only white males.
Okay. Very good. So Strauder's a different case, right? Strauder wasn't a challenge to the murder statute, kind of like in the cruikshank analogy, right? Strauder involved a challenge to the procedure by which the jury pool was selected, right? So when Strauder's case was going through the courts, he argued that the exclusion of black men from the jury, by the way, it wasn't about women either. He wouldn't even go that far, just that excluding black men from the jury deprived him of his rights. Now, Kyle, let me ask this question. Did Strauder seek to have his case dismissed outright because of the West Virginia law? What exactly was Mr. Strauder looking to do? Remove it to federal court, right? You guys studied in civil procedure removal, right? Generally, if I sue you in state court, let's say, and let's say we're diverse and we have the requisite dollar amount in controversy, you can remove the case to federal court. That's for civil cases. Don't get these confused. In civil cases, it's pretty easy to remove a case to federal court. All you have to have is diversity, for example, and the amount of controversy, or maybe there's a federal question, right? The thinking is we want federal cases litigated in federal court. But did you ever stop and think, what gives Congress the power to do that? How does Congress have the authority to deprive state courts of their jurisdiction? You filed it, you chose your forum, right? Why does Congress have to come and say, no, never mind, just kidding, state courts, you can hang on, go to the federal court? You never probably thought about it, did you? Right. This case is even different. This is not a case where a plaintiff sued a defendant. This is a case where the state of West Virginia is prosecuting a person who committed a gruesome murder in their territory. And then Congress comes along and enacts a removal statute. And the removal statute says that if a person is being deprived of certain rights in state court, the case may be removed to federal court. Right? Everyone with me? All right, so Braden, if you remember from CivPro, generally what happens once a removal motion is filed, do you remember what happens? Does anyone know? Okay, I'll tell you. I'll come back to you, Braden. This wasn't fair. In civil procedure, when you file a removal motion, the state court proceedings are put on hold immediately. And then the federal court gets to decide whether the removal motion is proper. The federal court says that removal motion was proper, then the case stays in federal court. Or the federal court can say, no, there's no diversity, for example, remand back to state court. But the state court proceedings are put on hold. Braden, was Strauder's trial ever put on hold? No, I don't think so either. He was basically prosecuted till the end. And then he appealed that conviction to the Supreme Court, arguing that because he was not afforded a trial in federal court where there was an integrated jury, that his conviction was invalid. This might remind you of Prigg v. Pennsylvania, which is another criminal case we studied, right? Where Prigg was convicted in the Pennsylvania courts of kidnapping the slave. And then he argued in the Supreme Court that the Pennsylvania liberty law was invalid. Why? He argued that the Pennsylvania liberty law was in conflict with the federal Fugitive Slave Act. This case is somewhat similar, but almost in reverse. Strauder argues that his conviction was invalid because the removal law conflicted with the jury segregation law. Everyone see that? Strauder argued that the conviction was not valid because the state failed to comply with the removal law. So therefore, the court had to decide, was the removal law valid, right? Now, in the abstract, the removal law is fine, right? But the question is, in this case, was the removal law appropriate? In other words, did Mr. Strauder put forward the evidence to show that he was being deprived of his rights protected by the 14th Amendment, right? Was he denied the rights he was entitled to under the Constitution? And Braden, what was the court's holding here? Okay, tell me why.
I believe it's I think the Civil Rights Act of 1875.
Yeah, and let me just pause you for 1 second. There are a lot of civil rights acts, and it confuses students because they all have different years, right? There's the Civil Rights Act of 1866, there's the Civil Rights Act of 1870, 1875, I think there's 1964. There are a bunch of civil rights acts. I don't want you to kill yourself remembering the years, but somewhere in your notes, when you have your notes on Strauder, just write Civil Rights Act of 75. Just keep that somewhere in your notes. It's not like super important, but I want you to understand these are different laws that did different things. Later today in class, we'll do the Civil Rights Act of, we'll do the civil rights cases, I'm sorry. Again, the civil rights cases, which considered the Civil Rights Act of, oh boy, I don't want to screw up the year. It was 1875 also. Okay. All right. So Strauder argues that limiting jury service denies them the rights protected by the 14th Amendment. And the court actually agrees, right? This is one of the few cases decided during this era where the court actually found a valid exercise of 14th Amendment powers. The court said that the guarantee of equal protection clause protects a right to a trial by a jury selected without discrimination based on race. Okay? Now, let's go to the 14th Amendment. I have the text up here on the screen. Okay? Kimberly, let me ask you a question, please. Does the court actually step in and argue that West Virginia can't enforce its its segregation law on the jury? Is that what the court's holding is here?
No.
What's the court's actual holding? What does the court actually hold?
Congress had the power to enact appropriate legislation to enforce
Yes.
equal protection of the laws.
Okay, very good. And this is a point on which I have a bit of a soapbox on, I'm sorry, but I think most people misunderstand Strauder. And in fact, the Supreme Court does all the time. We had a case this past term where the justice said that the court struck down the West Virginia law. I don't think it's exactly right. I think the court did something different. I think the court recognized that the West Virginia law deprived Strauder of his rights protected by the statute. Right? He was denied equal protection of the law. Therefore, because his rights were being deprived, Congress's Section 5 powers are activated. And let me explain what that means. Congress can only use its Section 5 powers to remedy a violation of the Constitution. Right? Remember Bernie v. Flores, City of Bernie versus Flores, right? Congress cannot enact substantive legislation under Section 5. Congress can only act remedial legislation. And here the court found that Congress could enact remedial legislation to enforce the Equal Protection Clause. Right? And because Section 5 gave Congress this power, then Strauder's case should have been removed. All right, so let's go to the poll question, see how you guys did with this one. I was letting that sit for a bit. This is pretty close, right? Remember the question was, Strauder held that the jury segregation, I don't like this app, you can't do two things at once. Strauder held that the jury segregation law violated the 14th Amendment. I don't think that was a holding of the case. I don't. I'm actually researching now, I haven't gotten quite through it yet, what actually happened afterwards. Did West Virginia stop using the segregation law? Not sure. I'm still researching it, right? But the court didn't come out and say that to stop it, right? Today, we usually think, well, the Supreme Court said this, that means the law is unconstitutional. But back then, it was the discussion was whether Congress had this authority, not whether the state was acting unlawfully by itself. So I think the better answer is false, but I can see why a lot of you put true. Well, let's just guess. It was 50-50. I don't know. All right, so questions on the majority opinion. All right, Afoso, you want to give me the dissent by Justice Field. What did he argue? Okay.
and that Congress didn't have the constitutional power to remove this case to federal court.
Why did Field supposed to think that an all-white jury was not a problem?
I think it goes back to the idea that blacks shouldn't be treated special, but be treated as
Yeah.
Normal citizens,
Yeah.
and that since if a white person was litigated, and he would receive equal protection on the all-white jury, and then a black person would too.
Yeah, I think that's right. Thank you. I think Field takes a position that is at once insane but at once not. He's basically saying we shouldn't presume that an all-white jury will be unfair towards a black defendant, right? We should presume that jurors are fair. And he said we shouldn't try and add black jurors so that a black defendant would have a more fair trial. The presumption that Field is relying on is that black jurors will be more favorable to black defendants. But the flip side is it probably was not the case that an all-white jury would be fair towards a black defendant. So it's sort of this weird thing where he's okay with the notion that the all-white jury would be fair, but he worries that adding black people to the jury would make it less fair. If you catching my drift? Now, I had always assumed this case was a situation like remember To Kill a Mockingbird? Did you see that movie, or at least read the book, right? Where he basically had a black defendant for murder, an all-white jury. I just assumed that was his case, right? Where the black defendant killed a white person, but then he actually murdered his wife. So this is like not the case you think of that you would need to have this sort of Atticus Finch type argument to save the case. So this is like this is a weird case where maybe it would have been fair, maybe not. But Justice Field sees no problem with the segregating jury because he thinks the jury will be fair. I don't know. Okay. But he was the dissenter, right? The court upheld the Civil Rights Act, and to this day, this removal statute exists. During the 1960s, you had a lot of the you had a lot of these really gruesome cases where you had black defendants who were charged with bogus crimes, and they removed it to federal court, and the cases were immediately dismissed. So this didn't have much of an impact in the 1880s. I just don't think there were that many cases like this. But in the 1950s and 60s, later on, these statutes became quite important to get federal court. To get these sort of bogus cases out of federal court or out of state court into federal court. Okay. Any questions, people, on Strauder versus West Virginia?
I have a question.
Oh, yes, sir. Nolan, go ahead, please.
Field talks about, women and children aren't allowed on the jury. Is there any reason that we should think that a jury should be unfair to them?
Yeah.
Why does he even bring up children? Could children be put on trial in what year was this?
80, I think. Yeah, let me address. I think Nolan raises a fair point. Let me talk about that for a minute, please. I'll go to you a second, sir.
No,
Oh, you're scratching. Okay. Now, let me address your question for a minute, Nolan. Why only men, black and white men? Why not women? At the time, I don't know if any state in the. Actually, I shouldn't say that. There were some jurisdictions who allowed women on juries. And the reason why this actually, let me take a sidebar. Were women allowed to vote? In some jurisdictions, the voter rolls were made up of people who were eligible for the juries, right? In other words, how do they call you for jury duty, right? Are you on the voter roll, right? Even today, the reason, if you register to vote, you're likely to call for jury duty. So there were some places where to get women to vote, they first made them eligible for jury service, and it was sort of connected, like, if you did one, you did the other. But why were women not eligible to serve on the jury? Okay. What if you were a woman who being tried for a crime? Would you have a fair shot if you had an all-male jury? No one asked, what about children, right? We have juvenile crimes. They exist, right? Minors commit violent offenses. It happens. You want a jury of your peers? Can you have a jury of teenagers on your jury, right? So today, this is going to seem backwards, but when you have cases in which people are excluded from the juries based on their race or based on their gender, the allegation is not that the defendant is being deprived of right. It's that the juror is being deprived of right. Right? It's almost backwards from what Strauder is. Strauder is Strauder getting a fair trial? That's not how it's looked upon today. Today, it's when you exclude a black juror, you are depriving the African American person of his rights. And when you exclude a woman from a jury because of her sex, you're denying the female juror her rights to serve in a jury. Right? That's actually a political right to serve on a jury, and that excluding you based on your race is denying you your rights. Now, no one asks, what about children, right? Well, if a 15-year-old walks up to the courthouse and says, Your Honor, I want to serve in the jury, I say, that's nice, go home, right? You know from contracts that minors are not of the age capacity. They can't make contracts. They can't do a lot of things, right? Minors are deprived of a lot of civil rights. I'm sorry. Minors are deprived of a lot of political rights. Jury service is one of them, right? But minors have other rights. I can't go and try and kill a minor and just get away with it. They're protected by the law the same way anyone else is from crime. So what you see is that when you have these sorts of political rights, like jury service, people can be excluded, men, women, children sometimes. But sort of these, we might call natural civil rights, you cannot exclude minors from. I know that wasn't even remotely close to the question you were answering, but it's a very complicated way to issue over whose rights are being violated when you exclude someone from the jury. Is it the defendant who's not getting a fair trial? Or is it the juror who is being excluded from civil service? Make sense? There are a lot of cases when you get to criminal procedure. Have anyone taken CrimPro yet? There's one case you'll need to know called Batson. B-A-T-S-O-N, Batson. Just write that one down, Batson. Batson was a case in which a person was excluded from the jury for their race, right? When you're selecting a jury, you get what are called strikes, where you can challenge someone. And there are two types of strikes. One where you challenge someone for cause. That is, you say that this person is biased. Maybe he's friends with the defendant, or maybe he has a financial interest in this case, right? Okay. If a prospective juror is next door neighbor to the defendant, you should probably kick him off the jury. All right. The second type of a strike is called peremptory, a peremptory strike. With a peremptory strike, you don't have to give a reason. You say, you know what, Your Honor, I want to strike this juror from the pool. Okay. Generally, with a peremptory strike, you don't have to give a reason. But let's just say you have a jury pool of 10 black people, and the defendant's black, and use all 10 of your strikes for all 10 African American jurors. Well, the court might say, something's up. And then the defendant counsel raises a Batson challenge, saying, Your Honor, this is unconstitutional. These cases arise a lot. Has anyone ever served on jury duty? Couple people. You list your race on, you ask you to fill out a form, right? And you list your race. And the defendant counsel is going to be very careful that if all the black jurors are being struck, that you raise one of these challenges. Now, I was called to jury duty last year for the first time in a while. I was bounced because I was a law professor. You do not want me in the jury because, in general, lawyers get bounced from juries. Let me tell you why. In court, the jury finds facts and the judge finds law, right? You all know the law better than the other jurors. And once they find out that you're a lawyer, they're going to ask you to explain stuff to them. And you can't do that because then you are explaining the law, not the judges, right? And I recognize that, oh my God, this is going to be so bad because they were just screwing stuff. They were just making mistakes. I was like, oh, this is just... So they bounced me pretty quick. This is the first day. But at one point during the voir dire, or in Texas, they voir dire, where they asked questions of the jury, they were saying, Professor Blackman, what does the Fifth Amendment say? I'm like, oh no. No, I think I said which clause. That's not what they were looking for. They said self-incrimination. Yeah, that's in the self-incrimination. Due process, I don't know. And I'm like, oh, there's no way I'm getting picked. It's like, Professor Blackman, tell us. I'm like, oh God. And then like I knew what was going on, but I couldn't tell people what was going on. So like I just played dumb. I was like, just strike me already. And they struck me for cause, which I think was a very good reason. Actually, maybe it was a peremptory strike. I don't know. But you don't want lawyers on your jury, except if you're in Washington D.C. That's such a high population of lawyers, you can't get a jury pool without an attorney on it. And every couple of years, like Justice Kagan or Justice Breyer goes to jury duty. It's very cute. It's very cute. They sort of sit there with their little book and they read all day and they get excused. They're not getting picked. It's not going to happen. It's just there's no way you put a Supreme Court justice on a jury. Although, maybe keep them off the bench for a while, see what happens. You put them like an OJ trial for a month. Yes, Rich.
Would most law students probably also get picked if they figure out law school?
I think law schools have a harder time because you have no flexibility in your schedule, right? People skip class apparently, but a jury can take, in state court, a trial can take a couple days straight, and you can't come to class. I would have canceled class if I got picked on jury day. I think that would have been a worthwhile cancellation to prove a point, but I don't think students have that liberty. But your question is, assuming it was during summer break.
Yeah.
I think I would also bounce a law student. The average law student, the average 1L, knows about as much as a practicing attorney about just the basic stuff. And I think I don't know. I would love to, but I don't think I'm ever going to get picked. And this was a high profile. It was like a police brutality case. It was actually sort of high profile one, where there was an off-duty police officer who was working security at one of the petro plants, and like he struck a person with an object, some sort of blunt object, and the Harris County DA charged this person with basically aggravated assault. So basically, you had an off-duty cop being charged for basically assaulting someone. And those cases are rare. So this was a pretty high-profile case. Actually, I don't know if it went to verdict. I'm not even sure. I didn't check, but that was a case. So I'm Googling now frantically. All right. Any other questions on Strauder before we move on? Okay. Let's go into the next case. The next case has a confusing name, and it always trips up students. And the reason why the name trips up students is it's similar to the law, which is not a coincidence, right? The next case is called the Civil Rights Cases. And it wasn't just one case. It was several cases that were consolidated together. What do I mean consolidated? Very often the Supreme Court will hear several appeals that raise the same issue, right? For example, you had the Obamacare case. Remember, there was a case from Florida, and a case from DC, and a case from Virginia, right? There were several cases together. They put them all together and give it one name. With the Obamacare cases, there was a nickname that never stuck. People wanted it to be the healthcare cases. Just the name never stuck. We also had the lottery cases, which consider the ban on lottery tickets. We had the slaughterhouse cases, which were several cases involving butchers. Okay. This one is civil rights cases, which are several cases involving the Civil Rights Act of 1875. The Civil Rights Act of 75 was the most significant enforcement act passed by Congress. This was like the furthest the Reconstruction Congress went. This was 7 years after the 14th Amendment was ratified. After this, things started going a little bit downhill. Why? The southern states were readmitted to the Union, and the Southern Democrats started to oppose civil rights laws. So this was like the last hurrah, right? The last major time when the Republicans had supermajorities and could pass these sorts of broad legislation. The Civil Rights Act of 75 said, I'm going to read parts of it, that all persons in the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land and water, that is railroads and boats, theaters, and other places of public amusement. subject only to the conditions and limitations established by law, and applicable alike to citizens of every race and color, regardless of any previous condition of servitude. Okay. Earlier this semester, we studied two cases from 1964. Heart of Atlanta Motel and Katzenbach versus McClung. These cases considered the Civil Rights Act of 1964, which looks pretty similar to this law, right? Not exactly, but it's in the same ballpark. That law banned segregation in places of public accommodation on the basis of race. Now, again, we have a Civil Rights Act of 1875 and a Civil Rights Act of 1964. So basically 90 years passed between these two laws. The Civil Rights Act of 64 was upheld based on Congress's powers to regulate interstate commerce, right? Remember, because the people were traveling down south and they had to cross through state lines. Therefore, they stopped at the hotel. And that the barbecue used products that traveled from other states. But the Civil Rights Act of 75 wasn't primarily about commerce between the states. Maybe it was inadvertently, but it wasn't primarily about commerce. Instead, the law was premised on the 14th Amendment. Specifically, Section 5. And the question presented was whether Congress had the power under Section 5 to prohibit segregation in places of public accommodation. There was no question the states could do this, right? Or most people don't disagree. But the states would have been allowed to enact these sorts of laws. States regulated common carriers all the time. But here the question is whether Congress could regulate these public facilities. All right, everyone with me? All right, Michael, you want to give me the facts, please, in civil rights cases?
Yes, so Congress passed the Act of 1875.
Good.
Prohibiting the discrimination against individuals. They consolidated the cases. So with this one, the first case was the Stanley case.
Okay, good.
Yeah, where he was discriminated against. They denied him access into the hotel.
Very good.
His race.
Very good. Very good. Just give me the couple of facts of the different cases, please. What were some of the types of businesses that were segregationists at the time? You mentioned a hotel. What other businesses were?
Hotel, theaters.
Theaters, okay. What else?
Stores.
Okay, good. Yeah. These are places that we would today call places of public accommodation, right? Hotels, theaters, restaurants, stores, right? And historically, when you had some of these facilities, they were called common carriers. Okay, what's a common carrier? A common carrier is a business that is required to take all comers, right? Anyone who comes in their store, they're willing to pay the fee. You gotta take them, right? You can't turn them away. But following Reconstruction, actually not following Reconstruction, but after Reconstruction, many states began to allow segregation. And this wasn't just a southern thing. These were houses of business in New York and in San Francisco and places that you wouldn't think are segregation. It wasn't just the South. All right. Now today, generally we think of violations of discrimination law as a civil matter, right? That if you exclude customers on the basis of race, you're going to get sued. Right? Angela, were these civil cases? No. What kind of cases were these? Criminal. Who was being charged with crimes here? Yes, very good. The reason why the Civil Rights Act was so significant was it made it a crime. A crime to deny people the privilege to use your business, right? Which is not how we think of it today. So I have also here Section 2 of the Civil Rights Act, and it says any person who violates this section by denying any citizen the enjoyment of these privileges shall be guilty of a misdemeanor and fined not less than $500. That's a lot of money back then. And can be imprisoned not less than 30 days or more than a year. So you can spend up to a year in prison for running a segregationist, running a segregated business. Right? This was a significant sanction. Right? This is similar to cruikshank, where you had federal prosecutors come in and charge members of the lynch mob with murder. Right? It wasn't just suing you for damages. They wanted to throw them in jail. Here, too, if you excluded people on the basis of race from your business, you'd be thrown in jail for up to a year. They were trying to send a very stern message. Okay? So, Desiree, what happened in this case? What happened? What happened with so the business owners were charged with crimes, right? What happened?
They basically questioned the constitutionality of the Civil Rights Act of 1875.
Exactly, right? What did the business owners argue?
They argued that it, because they were private businesses and not
Very good.
like state government businesses, then the Civil Rights Act had like nothing on it.
Okay, very good, very good. Thank you so much. The business owners, sorry, someone just walked by. The business owners argued that the Civil Rights Act of 75 was invalid as applied to them. Okay. Why did they argue that it was invalid? Because they were private businesses, right? They said, look, Congress has the power to protect certain things, right? Congress has the power to protect violations of the law. Violations by whom? The business owner said, by states. Look at the 14th Amendment. No state shall make, no state shall deprive, no state shall deny, right? They said, look, everything in the 14th Amendment is about state action. State action. These people, the business owner said, we're not state actors, we're just businessmen. Therefore, Congress cannot regulate our businesses, only the states can. And the court accepted this argument. This case gave rise to what's known as the state action doctrine. The state action doctrine. It's still good law today. Right? The state action doctrine is still good law today. It's cited in a lot of cases. And it came from this decision, the civil rights cases. Right? This case basically said that the federal government has no role to limit, under the 14th Amendment, private businesses. This doctrine is why Heart of Atlanta and Katzenbach were premised on the Commerce Clause. Right? Even in 1964, the court was not willing to reverse the civil rights cases. Right? And Justice Douglas, if you recall, would have done that. He said that we need Section 5 powers to enact the Civil Rights Act. But the other 8 justices said, no, we'll do it based on the Commerce Clause. Right? So I want you to see the relationship. Because the court narrowly read the Section 5 powers in the civil rights cases, the court would later expand the scope of Congress's commerce powers to compensate. Right? So this case adopts what's called the state action doctrine, and it holds that Congress cannot use 14th Amendment to prohibit private segregation.
Had sovereignty.
What do you mean sovereignty?
Because I believe people with sovereignty, and so that.
Ah. So you're saying that the businesses actually have basically state power, that they are kind of like state? Is that what you're getting at?
I thought that the federal government couldn't regulate private businesses or private individuals because they had sovereignty.
Oh, I see. You think of Chisholm versus Georgia, that the people are sovereigns?
Yeah.
Oh, I see what you're saying. That's creative. I like it's like a libertarian argument that businesses are free and they can't be regulated by the federal government. I think I'd be an argument for the state police power, right? Can the states regulate businesses? And Slaughterhouse said that they can, right? Because they can tell the butchers how to run their shops when they can do that. But I see your point. But let me make a different point, right? The effect of this decision was that private segregation was off limits, right? I want to pause here and just make a note. Caroline, the court here says that Congress cannot prohibit state action. I'm sorry, Congress can only regulate state action, right? Just fast forward for a minute to the last case, Plessy against Ferguson. What was the law at issue in Plessy?
It was the railroads, the segregation on the railroads.
Was this something the railroads did voluntarily?
No, it was state action.
Oh, so Carolyn's right. I want to just pause on this point for a minute. Plessy involved a state law. Louisiana passed a law that said all railroads must be segregated, right? Caroline, why wouldn't Plessy, the law in Plessy, violate the Civil Rights Act of '75? This was a public conveyance on land, people being denied access on the basis of race. It's state action. Why wouldn't the law in Plessy violate the Civil Rights Act of '75? You know, think about it. You want to take a guess? You want to take a guess? Yes?
It was also acting upon individuals, their right to whether intermingling or having the right not to intermingle.
You're right, but my question is, why wouldn't the state segregation law conflict with the Civil Rights Act of '75?
Is it because they weren't denying their right to the accommodation, they were giving them the right, but it was separated?
Well, that might be the case, but the court says the full and equal enjoyment. So you're saying that it was equal.
I mean, I don't think it was equal, but
Okay.
how they
Nick?
decided it.
That's what I was going to say, is that it's separate, but it is the same
Did the court
amenity.
in your excerpt of Plessy, Angel? Ooh, what year was civil rights cases? 83. What year was Plessy? I think it was 90? 96. So Angela, you think the court invalidated the statute? Is that what I think you're making a good argument. Is that the argument?
Yes, in 1875, it was made, 1830, it was invented.
So the law had no effect anymore. Matt, you want to add something? Your hand was up, I think, also.
Because the railroad was a private business.
But it was a state law. Now let me blow your minds for a bit. The courts actually strike down laws. Now when I say this, most law professors get very antsy. It's like, what do you mean, Josh? Strike down. Now the court will always say, we invalidate the statute, we strike it down. I try very hard never to use that phrase. If I do, I'm sorry. I actually Control F'd the entire book and took out every freaking reference to strike down and invalidate. Randy will not be happy with me that one. And the reason why is that courts don't have the power to actually remove a statute from the books, right? All the court can say is that we declare this law unconstitutional and it can't be enforced in this particular circumstance. Think of like a estoppel, right? That this law can't be enforced here. Even if the civil rights cases was correct and that the state action doctrine applies, this statute still is valid when there is state action. Let me say that again. Even if the civil rights cases is correct that this statute cannot be applied to private conduct, this statute is still in the books. And the statute can still be used to prohibit state action. Right? It's not in your book. It will be in the next edition. But in the Plessy case, they actually discuss and say, well, we don't have to consider the Civil Rights Act of 75 because it was invalidated. It was void, right? Angela's point. I think that's emphatically wrong. And here we have a case where Congress puts forward this really broad civil rights law. The court says, well, this can only be applied if there's state action. Then a decade later, there's a case with state action, and the court says, no, we can't apply it anymore. Right? It's just, this is why I get very annoyed at the court strike down the law. I don't like it for this reason, among many. But this statute would have still had validity for public laws, for Louisiana's segregation law. Everyone see what I'm getting at, right? But the court sort of ignored that. And Harlan, in his Plessy dissent, kind of gets annoyed at this. He's like, we have this law. It's here. It's in the books. But no go. Now, I think Deanna raises another fair point where they've just said, well, full and equal. Does full and equal mean separate but equal? I mean, just look at the language, right? Full and equal. I know you're nodding your head like, no, but I mean, even assuming separate but equal works for the 14th Amendment, the court would have said the same thing for the statute, right? If separate but equal works for the 14th Amendment, it would also work for here. In other words, if the Plessy statute was consistent with the 14th Amendment, then it did not violate the Civil Rights Act. Why? Because the Civil Rights Act cannot go beyond the 14th Amendment, right? It cannot be substantive. It can only be remedial. So what I'm saying now actually probably would not have changed the outcome of the case. I think Deanna's right. But at least to have acknowledged that the statute still has effect beyond the scope of what they said. Everyone understand that? I want to blow your minds one more time. Now, I asked Michael at the beginning of this topic, what were the places of business? There was a railroad. I'm sorry, damn it. There was a theater. There was a hotel, an inn. There was stores, right? There was also a railroad. Huh? Yeah, it's not in your book. It'll be in the next edition. One of my students pointed this out last semester. I was blown away. There was actually a railroad that was traveling from, I think it was Tennessee to Virginia, or maybe the other way. It's not in your book. It's not there. There was actually a railroad, a husband and wife, traveling from Tennessee to Virginia or the other way, but it was traveling across state lines. That's actual interstate commerce, right? An actual train going from one state to another. Why did the court not uphold that exercise, right? Maybe you can't regulate local businesses like a hotel or a theater, but why can't you allow Congress to regulate interstate railroads? Ready for this? The court says, well, we're not going to consider this. Why? Because Congress didn't identify the Commerce Clause as the basis for this law. That Congress only relied on Section 5. Therefore, we will not consider an alternate ground to uphold the statute. This is like the exact opposite of Obamacare, right? Where usually the court does everything in their conceivable power to find ways to uphold a law. And in this one, they say, well, because Congress didn't rely on the Commerce Clause, we're not going to consider it. And Harlan, in dissent, is flipping out. Like, what do you mean you're not going to consider this, right? Who says that you need to give the precise reason why in a statute? Shouldn't courts find ways to uphold it? So what I'm trying to get at here is that the court took every conceivable way to give this statute zero effect. Everyone see where I'm going with this? Yeah.
Is this why 89 years later, when the Civil Rights Act of 64 is passed, they rely heavily on the Commerce Clause?
Precisely, yeah. They have to rely on the Commerce Clause in 1964 that is, because there's precedence in the books and the court doesn't want to overrule it. Put a hand there?
Yeah, I was just going to say, like, isn't that kind of similar issue that kind of came up at the end of Cruikshank, where they were like, oh, y'all didn't bring up race, so we didn't really consider it.
Yeah, okay, good analogy. Thank you, Nick. If you recall at the end of Cruikshank, they say, well, doesn't this violate the Civil Rights Act of 66 because persons being deprived of his rights based on race? And they say, well, there's nothing in the indictment, right? There's nothing in the text of the indictment which suggests this was based on race, which of course it was. It was a freaking massacre, right? We all know what happened. It was in the newspapers. There were photographs and wood cuttings of it, right? Okay, why am I giving you all this sort of this entire spiel? After Reconstruction, there was a serious, debate about whether the country would actually change in its structure, the relationship between the federal government and the states. The Republicans in Congress said, yes, we need to change this radically. And the court said, we're not game for that. We're going to not sanction this change. Just imagine hypothetical for a minute, right? Imagine civil rights cases came out different. Would Jim Crow still have risen? Now, I don't know. Maybe the answer is yes. I don't have an answer for you, but I think it would have been a lot different, right? If private business owners were being thrown in jail for having segregation, would they still have done it? Maybe the answer is yes. I don't know. I think maybe the answer is no. If Plessy had come out the other way, right? Let's say the court said, well, private businesses can segregate, but the state can't enforce this. How would that have affected the rise of Jim Crow? Now, again, it's possible the exact same thing would have happened because people would have ignored the courts. Think of like Cooper against Aaron, right, with the school desegregation cases, right, where the governor of Arkansas was like, all right, screw it, we're going to just shut down the schools, right? So I can't tell you with any certainty what would have happened. I think it's a hard question. But these sorts of decisions enabled the rise of Jim Crow to the extent that it did until we got to '64 with the Civil Rights Act. So again, I can't tell you how history could have changed differently. Maybe people just ignored the courts altogether and said, screw this, we're not going to integrate. I don't know. But it's just worth thinking about for a minute. Yeah, Josh?
So the segregation statute in the Plessy case, is it likely that came about sort of as a result of the outcome or interpreted outcome of
Yes.
the civil rights case?
Yes, yeah. I think Josh raises a good point. Josh, had the case in civil rights cases gone the other way, would Plessy have even been a feasibility? Yeah, no. If civil rights cases came out the other way, and they said on places of public conveyance, which is basically a train, right? You can't have segregation. That means state also. So you would not have gotten to Plessy but for civil rights cases. Now, most people don't know the civil rights cases. They just don't know it. It's just not a case they know. People know Dred Scott. They know Plessy. They know those names. I don't know why civil rights case is not more well known. It was a far more significant case, right? It wasn't just one local Louisiana law. This was a federal law that applied nationwide to prohibit segregation. It doesn't have the same sort of name recognition. We all know Roger Taney wrote Dred Scott. Who wrote civil rights cases? Justice Bradley. Who the hell is he, right? Even Plessy. Who wrote Plessy? I think it was Justice Brown. Who the hell is he, right? It's just funny that just important cases just don't get the same sort of recognition and common knowledge. I couldn't tell you why. All right. I'm going to move on to the 13th Amendment in a minute. But does everyone get the 14th Amendment state action argument? Yes, sir, Matt.
This last clause about or deny a person within its jurisdiction the equal protection of the law, the failure of the state to
yes.
protect them.
Yes.
State action.
Yes.
Basically,
So Harlan, yeah.
I mean, that's what Harlan's arguing.
Yeah, I'll get to Harlan in a minute, but I'll jump ahead a little bit. Harlan argues that one of the privileges of citizenship is the ability to enter these public accommodations. All right, that's one of the privileges of citizenship. Again, that's not consistent with Slaughterhouse, is it? And Justice Harlan argues in his dissent that the state's failure to protect these rights is a violation of equal protection. Majority rejects that. They say it's not a privilege of citizenship, and the state has no duty to protect them. But let me focus on Matt's point for a minute. I'll come back to the 13th Amendment. Today, when we have cases involving equal protection, it doesn't actually mean to protect people equally. These are cases in which people are being treated differently, right? Where you have a school segregation law, where white students are allowed in this school and black students are allowed in this school, right? The law is not being applied equally, we would say. But the original meaning of equal protection was quite different. It's something where Randy and I agree, and not everyone agrees with us, but I'll give you our position, if I may. Equal protection meant protection that's applied equally. That if there are certain rights, the state has an obligation to ensure those rights are enforced. That if you have a right to enter a place of public accommodation, and you have then a business that segregates, the state has to come in and ensure that you have access to that facility. Protection, ultimately, literally protection from violence, right? That if you have a statute saying you cannot murder, right, it has to be enforced equally, right? You know, if you have a lynch mob of the Ku Klux Klan going around lynching people, and the state police does nothing, they are depriving you of your rights of equal protection. They're not protecting people equally, right? That is how we understand equal protection to be. That's what we understand equal protection to mean. Harlan kind of embraces that, where he says you have the state has to intervene. But the court doesn't accept that, and they reject that, especially in Cruikshank, right? My goodness, you have people being lynched, murdered, burned alive, and the state did nothing. So the sort of protection argument we're advancing has not been embraced by the courts. But good question, Matt. Any other questions on the 14th Amendment? We'll do 13th in a minute. Yes, sir, Nolan?
These places of public accommodation, a lot of them require permits from the state, right? So
Yeah, good point, yeah.
not seen as
Yeah, this is Harlan as well. Harlan argues in his dissent that these are actually state actors, right? Harlan argues in his dissent that if you are a business, you need certain licenses from the state. And by virtue of having these licenses, you are now a state actor. Now, Nolan, let me flip that back at you. If Harlan's right, is everything state action? Is there any business that can operate absent state licensing? Is like, you know, a coffee shop, or you know, if you have a you know, a private club that you know, has an occupancy permit to allow people in the building, is that a place of public accommodation? Yeah. The problem with Harlan's dissent is if it's taken seriously, then everything's state action. Then basically the federal government can regulate everything, and it gives federal government an absolute power of all transactions. Forget Farmer Wickard Filburn, right? It's state action, right? That, you know, growing crops is a privilege of citizenship, and then therefore Congress can regulate it. We don't need the Commerce Clause. So the Harlan position on the 14th Amendment runs into a quick wall where everything is state action. Now, some of these places were. I think the hotels were, the inns were. I don't know about the theaters and the public amusements. I think that was a bit of a stretch. Historically, public amusements were not considered common carriers. Yeah?
when it comes to, I mean, like coffee shops, I mean, that's not a place of public accommodation like a hotel or anything.
But if Harlan's correct, the word is not public accommodation, it's state action, right? That's the phrase. And if it's anything that has a state license, and everything's state action. Maybe the answer is there should not be private clubs, right? That any place with a government license has to be open to the public. Maybe that's the answer. But that's a very broad argument for the 1870s. Let's do the 13th Amendment. The 13th Amendment and 14th Amendment differ in an important respect. The 14th Amendment applies to state action. No state shall, blah, blah, blah. The 13th Amendment is not so limited. It says neither slavery nor involuntary servitude shall exist. Shall exist. This is not a limitation on state power. It's a limitation on everyone, both the government and private individuals. So if you're a private citizen, you cannot hold a slave. Okay? Oh, okay, I forgot where I was. You've been on deck for a while, and I've been patiently waiting. Brandon, the 13th Amendment does not have a state action requirement. Does segregation in these places violate the 13th Amendment? Has the court approached this issue?
The majority says no.
Okay, tell me why.
Well, they both agree. They say that the test of the 13th Amendment is that Congress can enact laws that were necessary and proper to abolish all badges of instance of slavery.
Okay, let me just stop you right there. You're right. The 13th Amendment has two prohibitions, right? No more slavery, and no more involuntary servitude. And today we think of these things as synonymous, right? That they're the same thing, right? Slavery and involuntary servitude. But that wasn't how the thing was understood. Slavery was an institution. It was this broader dynamic that involved control based on race. It was this broad economic system. And then the court has this phrase, Brandon, badges of servitude or badges of slavery. What does that phrase mean? What's a badge? Yeah. Yeah. Remember the Scarlet Letter? You probably read that like in high school or something, right? Where she had the Scarlet A for adulteress. Remember that? Think of it kind of that way. That, okay, slavery is abolished, but the state is still making people wear badges, right? Reminders, remnants. I like that word. Remnants of slavery. Right? Even though there's no formal involuntary servitude anymore, there are things that the states are doing that remind people of servitude. And those actions are unlawful. And because those badges would violate Section 1 of the 13th Amendment, under Section 2, Congress then has the power to enact legislation to abolish those badges, to prohibit those incidents of slavery. Everyone with me? All right, Ray, does the majority think that denying access to these places of accommodation is a badge of servitude?
No.
Okay, tell me why.
We saw it more like these are social rights. These are more like public, or not public, but more like social privileges that people should be able to decide upon, particularly the private business owners, on who to let in and out of their businesses.
Yeah. So, Ray, let's just let me finish it up. Why did the majority, Justice Bradley, think that these sorts of black codes, as they were called, could not be badges of slavery? What about them? He thought that was, not a problem. Or let me ask it differently. What would have happened, Ray, if these black codes were considered forms of slavery? Well, what would have Congress then have had the power to do?
To remedy them?
Yeah, remedy what?
Those codes?
All of them. This is an argument similar to the question Nolan asked a minute ago, right? If Harlan was right that any business that had a government license with state action, then Congress could have regulated all businesses. We have a similar argument here. If Congress can abolish all badges of slavery, then Congress can regulate all businesses that are segregationist. And Justice Bradley says that goes too far. He says that every act of discrimination would now be considered slavery. He says mere discrimination on basis of race was not a badge of slavery. Right? The majority, again, 8 members, was not willing to give Congress this much authority to eradicate the black codes. Indeed, Justice Bradley notes that segregation laws existed in northern states even before the Civil War. So this was not something that was abolished by slavery. This was something that predated it. In other words, and even in states where you had no slavery, you still had segregation, which is not well known. That's why I always make a point of stressing these were in New York, it's California. It wasn't just in the Deep South. Okay, that's the majority. Everyone with me? All right, Sergio, what's Harlan's dissent? Maybe start with the 13th Amendment if you want, but how does Harlan respond on this 13th Amendment point?
Yeah, Harlan's basically saying that the badges and that this discrimination, that access to these public accommodations are basically like what slavery was. There's like an extension of slavery.
Mm-hmm.
Basically makes other races inferior.
Yeah, there it is. Okay, thank you. He says that the concept of slavery was not about involuntary servitude. It involved racial inferiority. Right? Again, it says, just look at the text, is involuntary servitude or slavery. They're different concepts. if slavery is premised on the inferiority of the races, right, the racial inferiority system, then these segregation laws operate in a similar fashion, that these people are not being treated in the same way. And Harlan says the civil rights to be enforced are the right to access places of public accommodation. Right? So you have, again, Harlan, who wrote the lone dissent. He wrote the lone dissent here, and he wrote the lone dissent a couple years later in Plessy. But Harlan articulates a very different philosophy. Right? He says that the purpose of congressional legislation was to enable the black race to take the rank of mere citizens. The difficulty has been to compel a recognition of the legal right of the black race to take the rank of citizens and to secure the enjoyment privileges belonging to them as a component part of the people for those whose welfare and happiness government is obtained. He fully embraces the notion that Congress can intervene to remedy these vestiges, these scars, these badges of slavery. The majority takes a very different perspective. The majority is like, well, you got enough, right? You got the 13th Amendment, you got rid of slavery, you don't need anything else, right? Once you take the rank of mere citizen, you're no longer the special favorites of the law. In other words, deal with it. I don't know that the majority quite understood what was ahead of it. Right? This was fairly early in the process of Reconstruction. But in the wake of the civil rights cases, the sort of black codes that existed sort of sprouted up and spread very wide and far and started to exclude people from all aspects of society, from voting, from owning property, from participating in any form of government, for running for office, right? They enact all these laws, and by the court's decision here in civil rights cases, those actions would not be challenged in the courts. All right, questions in civil rights cases? Again, an important case that most people have never heard of, which I think is unfortunate. Questions, civil rights cases? Okay, let's move on. All right, the next case always gives students the loops. Like, wait a minute, Josh. Whoa, 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 right? We have civil rights cases, was it 1883, I think? Right? Civil rights cases, 1883. And then 3 years later, we have Yick Wo v. Hopkins from 1886. How on earth do we go from civil rights cases in 83 to Yick Wo in 86, and then to Plessy in 96, right? How do we account for this disparate treatment? And I don't think I have a good answer for you, but I'll do my best. Matt, you want to give me the facts, please, in Yick Wo?
So the city of San Francisco in 1880 passed an ordinance that required that basically made it a crime to operate a laundry in a wooden building without a permit. You have to have a permit unless you're in a brick building. And about 95% of the building, of the laundries in the city at that time were in wooden structures. And when people who own laundries in wooden buildings would go to the city to get a permit, the law was being applied unequally in that 80 out of 81 non-Chinese applicants were granted permits by the city, while nearly all of the Chinese applicants were denied permits.
Okay. All right, very good. Yick Wo is one of these cases that seems like ahead of its time, but it's complicated. All right, so we had a case called Slaughterhouse. And in Slaughterhouse, the butchers argued that the Louisiana sanitation law that shut down their business was a violation of privileges or immunities clause. Right? And in that case, the court said, no, the 14th Amendment does not, the privileges or immunities clause does not place limits on the police power. right? Because privileges or immunities only protects certain rights of citizenship. Okay. The plaintiffs, actually not plaintiffs, but the business owners in this case couldn't rely on the privileges or immunities clause. For one, they weren't citizens, right? They were mostly immigrants. But also the PRI was basically killed. Instead, they relied on the other provisions of the 14th Amendment, the Due Process Clause and the Equal Protection Clause. Most people consider this case an Equal Protection Clause case, right? That the government failed to protect the people equally, that they treated the white launderers more favorably than they did the Asian launderers, right? But the case also involved the Due Process Clause, which is something not well understood. The business owners like Lee Yick, his name actually wasn't even Yick Wo, it was Lee Yick. Lee Yick argued that the refusal to renew his license deprives him of his property without the due process of law. This sounds a heck of a lot like the argument of the butchers, right? The right to earn the right to pursue a trade. What we'll see in the late 1800s is the sort of right to economic liberty, the right to earn an honest living, was litigated not as a privilege or immunity case, but as a due process clause case. And you sort of see this shift. But Yick argued that the San Francisco policy violated his rights under both the due process and the Equal Protection Clause case. Okay? Now, Josh, let me ask you a question. Why was Yick denied his license renewal?
I believe it didn't really specify too much.
Did the government have to give any reason why they denied the permit?
They didn't really have to give a reason why they denied or gave a permit.
Okay. Thank you, Josh. This denial is what we call arbitrary, right? You know this word arbitrary? Arbitrary means without any justification, right? Purely discretionary, right? Usually if you want to get a permit to, say, run a laundromat, I don't know, maybe they have to inspect it, make sure your equipment's safe, maybe you have proper ventilation, maybe you have things to put fires out, I don't know, right? There's stuff that maybe you would need to have a safe laundromat. But here, you just needed a permit. And the government had absolute discretion over who would and would not get a permit. Now, Hannah, let me ask you a question. When the government has absolute discretion over who gets a permit, what is the risk, right? When they can decide yes or no without any guidance, what's the risk?
Then they can discriminate.
They might use improper motives, right? If they don't have to put the reason on record for denial, they might discriminate. They might use a racial justification. Okay, now let me just pause here for a minute. We know 3 years later in Plessy that the court upheld separate but equal, 8-1 vote. The court didn't have a problem with any sort of discrimination there. Ethan, why is the court so troubled here in Yick Wo by an obviously racially motivated regulatory regime? Why are they so troubled by it?
I think they were troubled by it because it shows that the state had a mind that was unequal and oppressive to a particular class.
Why? In Plessy, a couple years later, you have an overtly racial statute, which is on its face racial, on its face. Why are they so troubled by the San Francisco ordinance? It's not an easy question.
Is it because it could lead to more severe discrimination down the road?
My God, you have a train statute saying this black car, this white car. I mean, is that Matthew? How do we square these two statutes? Have these two cases decided a couple years apart?
It's a good question.
It's a damn question. I'm asking it. So I'm asking you. I remember when I was a 1L, I had a moot court competition, and some judge asked me a question. I said, Your Honor, this is a good question. He's like, you don't ask. You don't, that's not. He said, that's never your answer to a question. I'm not picking on you, but I remember there's a one I said that to a moot court. It's like, don't say it. I'm like, okay. Always. He may have said, I know, that's why I asked it, or some sort of response. But anyway, Matt, how do we square these cases? How can we even think about being able to square them?
I mean, would it be because in this case, I guess this ordinance would affect their livelihood and lose their businesses and how they survive? I mean,
I think that's actually a decent answer. Where I think it's going in the right direction. The court by this time was starting to think about the due process clause, and they put a lot of weight in this word property. And here, quite literally, the state was depriving them of their property without any sort of process at all. It was completely arbitrary. And right, the word due process of law, you think of a procedure like a trial or hearing, but it also meant there has to be some justification, right? There's a reason why we're justifying the law. All right, so maybe one justification is that this gave the government just sort of naked and arbitrary power, right? But then we get to the second part of the opinion, right, where they give a very famous test. Let me read it to you. It says, though the law itself be fair in its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discrimination between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. That is pretty broad, right? I mean, that's like the sort of thing you would see in the 20th century opinion, right, in the 1950s. So Natalia, how do you square that statement I just read to you with Plessy 5 years later, or 3 years later, it says, separate but equal, or a decade later, I'm sorry. How do you square those cases?
Here they're saying that it's unfair because it's targeting the Chinese, but in Plessy they were saying that, I don't know how to.
I think you're on the right track. In this one, the statute's neutral, but it denies the rights to the Chinese people.
Yeah.
Whereas in Plessy, I think you're about to say it. What's actually going on?
They were it says black, coloreds, and white people. It explicitly mentions them, and they were saying that.
Is anyone excluded from the train?
No.
Oh, could that be it? I don't know if that's it. That's maybe one justification, right? In this statute, they're being denied their business altogether, whereas in Plessy, they were allowed to be on the train, but just in separate cars. There's another reason, which is not in your book, but I like to mention. I did a thing on C-SPAN on this a couple years ago. When people call it the C-SPAN, those are the people, right? But it was like this live program at night on C-SPAN on this case. There was another part that was at issue, right? This case involved a lot of very poor immigrant laundromat people. Launderers? That sounds dirty, but people who ran laundry businesses, right? How the heck were these people appealing their case to the Supreme Court? And the short answer is the Chinese government was bankrolling these cases, right? Right. The LeBron tweets, right? They were actually bankrolling. So too soon. Sorry. I feel like this is South Park, right? In 5 years, someone watching goes, what tweet was he talking about? The Chinese government was bankrolling these cases. There were various treaties between the United States and the Chinese government. And those treaties guaranteed the rights of Chinese people to work in the United States. So one of the elements at issue in this case was that there was an international relation aspect, right? That this local San Francisco government was basically messing up federal trade law and international relations. And one of my theories, again, I can't give you an answer, I don't know the answer, but one of my theories is that the court was nervous about having state governments screw up our relations with China at a time where immigration was a very divisive issue. It always is, right? But at a time when immigration between China and the U.S. was getting very contentious. That's one of my theories. I can't tell you for sure. But they didn't need to go through this entire business with the unequal eye and the evil eye and unequal hand. Like, that's language that's still quoted today. And you will still see that decision today in cases. Okay, what kind of cases you see it in? Where the law is neutral on its face, but the way it's applied targets one group, right? Where you draft a neutral law that says, everyone's equal, but the way it actually goes into effect is only one group's targeted, right? You see these cases pop up. Okay? So any questions on the majority in Plessy, Yick Wo? Yeah.
Are they like really attacking the statute itself, or more so the execution of the statute?
That's a good question. I think in this case they're one and the same.
Well, just going back to Talia's comment about how
Yeah.
the statute in Plessy said that it had to be separated.
On its face, yeah. I think what they're saying is the statute on its face, though neutral, is not valid. I think they're saying the statute itself cannot be enforced in any regard. Because, and let me explain this point well. A statute that makes the issuance of a license completely random is not a valid law, right? There's no guidance on why a permit will be denied or granted, and it's completely arbitrary. And the fact that the statute is so arbitrary means it violates due process. But that's only the first part of the opinion. I think the second half on equal protection is a little bit more fuzzy. Right? If they just stopped and saying this is an arbitrary statute, that would be the end of the case. But they went to the next step about this evil eye stuff, and then unequal hand.
Which is why I thought they were like focusing on the application.
It's a weird case, and it's just I teach it every year. I always have different thoughts of why they did what they did. I don't have a good answer. I saw another hand. Yes, Rosh.
Is it also possible that because this act, like it was so blatantly obvious that they were targeting the Chinese immigrant, as opposed to in Plessy v. Ferguson, it's more broader, that they're not, it's a separation of the races, and it's not just black race and the white race, but all races.
I don't know. I mean, every year someone says is, maybe the court was more hospitable to Chinese people than to black people. Maybe that's one answer. But then look at Justice Harlan in Plessy, where he basically says that Chinese people aren't part of our society, black people are part of our society, but Chinese people aren't. So I don't know. I don't know. I welcome your thoughts. Every year I sort of struggle teaching this case and make it sense, but I don't. Yeah, Nolan?
So I got a little lost when you asked the question why the court's so troubled here. Is it because of this, in Yick Wo there was this unbridled discretion and no justification for it?
Maybe.
Compared to Plessy where there was
It was a very clear bright line rule. I think that was sort of what I was getting at with Natalia a minute ago. That could be it. Again, I think there's a lot of stuff going on here. It's a complicated case. If you want, it's on my YouTube. I did a C-SPAN special, it was an hour long, and there was another professor in Asian American Studies from Columbia, and she and I were on TV for like an hour. And her perspective, she's not a lawyer, but she was talking about the sort of politics of the time, and she also sort of grappled with the case as well, right? It's a weird case. It doesn't really fit, and that's why I think it gives students a lot of difficulty. It's like, why can't you apply the evil eye test to the Plessy statute? I don't know. Then then Jim Crow might look a little different today. Yeah, it's anyway. I'm gonna move on to Plessy in a minute. Any other questions in Yick Wo? Yeah, go Matt.
That it sounds like one of the things that they've talked about since the Civil Rights Acts of the mid-1960s, this sort of concept of discriminatory effect.
Okay, good. Yeah, let me just take Matt's point. I encourage you all to take a class on employment discrimination, right? Even if you don't do employment law, you all work in offices, and every office is governed by these laws. So there are two major types of discrimination, and they're categories, but just two major categories. The first is called disparate treatment. Disparate treatment, right? What does that mean? Where you're treated differently because of your race, where it says, I don't want to hire any black people, so I'm not going to hire you, right? That's disparate treatment. That's easy to prove. right? There are other policies that aren't so clear. It's what's called disparate impact or disparate effect. That's Matt's word, right? Disparate impact. So let's say that a fire department uses a written test to admit firefighters. And as a result of this written test, a high percentage of African American firefighters flunk. Now, was the test adopted to punish black people? Maybe, maybe not. But let's say they said, I got an idea. The way we keep out certain types of races is by putting this neutral test, right? And in some cases, the courts say, it's a neutral policy, but the effect is to target only one race. And the court will say that this test is unconstitutional. And there are cases about this. So even today, the sort of difference between disparate treatment, like overt racism, and disparate effect, a neutral policy that has an effect of targeting one race, does pop up a lot. So you still see that today in employment classes. Good question. All right, anything else in Yick Wo? I think, David, are you next?
Yes, sir.
All right, David, you want to please give me the facts on Plessy?
Yes, sir. So it was a Louisiana statute that...
Always Louisiana, isn't it? We have a lot of Louisiana cases, don't we? We have Slaughterhouse, we have Cruikshank. What was that? Yeah. We have Slaughterhouse, we have Cruikshank, we have Plessy. Like 3 of our big cases are from Louisiana. I don't know what's going on, but we have a lot of Louisiana cases. All right, go on.
That basically required segregation on public railways as far as passenger coaches went.
Very good.
Plessy tried to sit in the white section because he was 7/8 white and 1/8 black, and they would not allow him and charged him under the statute, which was either a fine, I think it was $25 or 20 days in jail, either or. And then he charged the statute saying it was unconstitutional.
Okay, very good. Plessy, by the way, we don't have any pictures of Homer Plessy. If you Google him, internet will show you pictures. It's not him, right? It's someone else. I know who it is. I can probably tell you if you show me the one. But they basically took pictures of other black men from that era. They said, this is Homer Plessy. It's not him. In fact, last year we had a presentation at the law school where some professor came to present, and he had a PowerPoint up. And he said, and here's Homer Plessy. I'm like, that's not him. It was someone else. I think it was either a governor or a senator. It was someone else who. Anyway, we know what the guy looked like. We know where his grave is. It's in Louisiana somewhere. There's actually another cemetery that says we have the Homer Plessy grave. It's not him. So for whatever reason, there's like a lot of fake stuff about this guy. I can't tell you why, but we have his birth certificate. We know where he was born. We have a lot of paperwork. Just we don't have any pictures. So we don't know what he looks like. But Homer Plessy was picked for this case quite deliberately. He was phenotypically white. He basically looked white, but he had an African American relative in his family tree, and under the sort of Jim Crow laws, they at times had what you might call a one-drop rule, where if you had some African American lineage, you were black. Now, in other parts of the world, there were very strict distinctions. If you were half black, a quarter black, there were different rules for you. Latin America had a lot of these very stringent distinctions on race. But Homer Plessy was considered black. He goes to this train car, and he wants to get arrested. Okay, who the heck wants to get arrested? It's called a test case. Why is it called a test case? He wanted to get to the U.S. Supreme Court a challenge to this Jim Crow, this black code law. Okay, he got arrested. He got bailed out, right? I think it was like $500 bail. Who has $500 sitting around back then? No one, right? They were there to bail him out, and they got him his representation. The case goes to the Supreme Court. Oh, by the way, who's Ferguson? This is a weird Louisiana thing where you sue the judge who sentenced you. I don't understand why. I've tried figuring this out. I think I figured it out once and I forgot, but it was a weird thing where in Louisiana, you have to challenge the judge who sentenced you. What the hell? That doesn't make any sense. But anyway, that's who Ferguson is. So he was a judge in New Orleans. Okay, the case goes to the Supreme Court. The Supreme Court considers whether this mandatory segregation law violates 14th Amendment. Again, this wasn't the railroads' choice. The railroads didn't want this. It was actually very expensive, if you think about it, right? Forgetting whether they were like nice people, maintaining 2 cars was really expensive, right? They didn't want to have to do that, right? If they only needed 1 car, they could use 1 car. But the railroads didn't actually want this law. This was mandated by the state. All right, Nolan, walk me please through the court's analysis here in Plessy.
Well, they rejected the argument that the law violated the 13th Amendment.
Okay, let's start there, right? Why, we talked about a few minutes ago the badges of slavery, right? And the court in civil rights cases said excluding people from common carriers is not a badge of slavery. Does this law impose a badge of slavery according to the majority?
According to the majority, no.
Good, why not?
Well, they said it's within the power, or within the state's police power.
Very good.
I think the justification was that it was to promote security for the
Okay.
train, and
Yeah.
that separation does not necessarily suggest an inferiority.
Okay, good, thank you. All right, let me read a bit from Justice Brown's opinion. By the way, everyone knows Roger Taney wrote Dred Scott. Who knew who Henry Billings Brown is, who wrote Plessy? You never heard of the guy, right? I don't know why some cases get this salience of the... Plessy was a hell of a lot more destructive to civil rights than Dred Scott was. Like a couple years after Dred Scott, we had a war, right? Plessy was good law for almost 70 years. Okay. Justice Brown, Henry Billings Brown, wrote, a statute which implies merely a legal distinction between the white and colored races has no tendency to destroy the legal equality of the 2 races or reestablish a state of involuntary servitude. Right? In other words, this is not slavery. This is just segregation. He continues, the underlying fallacy of the plaintiff's argument is the assumption. In other words, Homer Plessy assumes that the enforced separation of the 2 races stamps the colored race with a badge of inferiority. Right? Homer Plessy says separating the train cars stamps us with a badge of inferiority. Justice Brown replies, no, you're wrong. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction on it. In other words, if Homer Plessy feels inferior by the separate train car, it's his fault. Right? It's his fault that he feels inferior, not the state's. This is similar to Justice Field's argument in the jury case in Strauder, that if a black person feels he will not get a fair shake in front of an all-white jury, that's his problem, not the state's. So Plessy more or less embraces the Strauder dissent approach to race. That if, in other words, if this is bothering you, it's your fault, not mine. Don't bother me with this. It's a remarkable statement, right? I mean, the court could have just said the first part, right, that this is not a badge of slavery. But then had to go another step further and sort of throw it back at Homer Plessy and say, no, this is you, right? If this is how you feel, too bad. Right? It's a remarkable holding. A lot of the reason why these cases are so anti-canonical is they go out of the way to make certain points they don't have to make. Right? They could have just said one thing, and it's like, okay, whatever. But then they have to go and throw gratuitous language back at Homer Plessy, right? Which was, I think, you call it a dick to whatever you want to call it, but they didn't need to say this. But there was language that was deliberately harmful. Right? Think of Dred Scott, where he says the inferior race and all this other stuff, right? It wasn't necessary. The case was about jurisdiction. But they go out of their way to sort of twist the dagger, so to speak, to explain, don't bother us with these cases. Right? It's a remarkable holding on the 13th Amendment. Right? I think it followed from civil rights cases. I don't think it broke any new ground on the 13th Amendment, but they had to add that sort of dig at the end. All right, any questions on the 13th Amendment? No? All right, Nick, let's go on to the 14th Amendment. How does the court justify the statute under a 14th Amendment challenge?
They say that Louisiana has wide discretion to determine whether or not
Mhm.
the reasonable.
What do you call that discretion? What's that thing called? The state's authority here. What's that called?
Police power?
Yeah, police power. And then what has the court understand the police power?
That I guess it's like I just said that they're allowed to operate it reasonably with wide
Reasonable,
discretion.
right? When the court says they must when the court says that the state can exercise its power reasonably, what reasonably suggests is there's deference involved, right? That the court will defer to a reasonable exercise, which says the good faith laws for the public good, and not for the annoyance of an oppression of a particular class. Now, why does this law, Sarosh, promote the public peace and good order? This is, I think, the second sort of outrageous part of the opinion. Or there are a lot of outrageous parts, but another outrageous part of the opinion. What about this law promotes public peace, Sarosh? Antoine?
So, at least from what I gathered was that Judge Brown saying that we're in a time of transition, and you have the white race and the colored race, and they'll get there eventually. But he says at this point we're just trying to accommodate everybody and make everybody comfortable.
What's the risk of having an interrated rail car? What do you think might happen? What does the state think might happen?
He thinks that it would just be chaotic. He thought
Violence. Yeah. So just follow me here, right? What is Louisiana's justification to promote public peace and good order? Right? What's the risk? If black and white people are asked to sit together, there may be violence. And we know which way that violence is going, right? It's going to be the white people engaging in violence in the black customers. And therefore, Louisiana says, we're protecting the black people by giving them their own car. I just want you to understand that point, right? This is what the majority embraces. That this is actually protecting the black people from the white violence. It's for their benefit. Separation will make them safe. It's a remarkable argument, just to say it out loud. But that's what's good. The police power is protecting these people to ensure they're not engaged in acts of violence and they're not harmed. Now, is that a hand? Okay. Now, is there any evidence that this ever happened? Of course not, right? It's completely, he just sort of made it up. But the argument is that this is for their benefit. Now, it was to promote inferiority, right? That's why it was imposed. But they said, oh, well, we'll just assume this other basis exists for the law. He then writes that the 14th Amendment was never intended to abolish distinctions based on color or to enforce a commingling of the two races on terms unsatisfactory to each other. But again, the law didn't enforce commingling. It prevented people who choose to sit together on the trains. So I think he gets it largely backwards. The court also made one note they want to flag. He said, look, we have some evidence here on what the framers of the 14th Amendment perhaps intended. At the time the 14th Amendment was ratified, the public schools in the District of Columbia were segregated, right? Congress had control over the public schools in D.C., and they were segregated. How could it be that the people who favored segregation in public schools would also favor integration on the railroads? Now, there are a lot of arguments against that we'll come to later when we do Brown. But this is a very common argument that to this day is raised as a criticism of originalism. That how can we favor the actions of those who segregated public schools? I think there are reasons why that's not accurate. But Brown raises that here. Okay. Questions in the majority opinion by Justice Brown? Yes, Roche.
Why is it that they got to take the secondary assumption when the defense was not even raising that? in this case, but in previous cases, they're not giving that to the plaintiff.
I think I understand your question, but I don't think anyone else did. You want to say it one more time?
Basically, why is the Supreme Court allowing a secondary basis for protecting?
Oh, about deference, is that your question? Right, so I think here's your question. Let me just, if I rephrase it wrong, just stop me. But I think Strauder is asking, in Yick Wo, the court was very skeptical of the statute, right? They weren't willing to accept alternate rationales, right? Facially neutral, but have an evil eye. Here, they took a law that on its face was not neutral. It was discriminatory on its face, but they were able to make all these other assumptions about maybe what Louisiana had intended. This is what we today call tiers of scrutiny, right? Generally, when you have a racial classification, the court is very skeptical. But what the court does in Plessy is they use what you might call a rational basis review, where they say, well, if there was some rational basis on which the statute is valid, we have to uphold it on that basis. And the Plessy court gives this sort of deference to the Black Code law that they did not give to the San Francisco law in Yick Wo. I think that's your question. Okay, thank you. Martin, walk me through Justice Harlan's dissent in Plessy.
Yeah, so he pretty much just says that separate but equal doesn't hold any weight to it, just because of the based on race and discrimination. It's also premised on the idea that you can't have separate but equal because of the Constitution is colorblind.
Yeah, let me just stop you there for a second, right? Thank you, Martin. Harlan says that the arbitrary separation of citizens on the basis of race is a badge of servitude, right? That this is a reminder of inferiority. And I think this follows from his opinion in civil rights cases about a decade earlier. But then he looks at the Equal Protection Clause, and he says that the Constitution does not permit any public authority to know the race of those entitled to be protected in the enjoyment of their rights. In other words, we have a colorblind Constitution that neither knows nor tolerates classes among citizens. He says there's no superior, dominant ruling class of citizens. All citizens are equal before the law. Now, I want to pause here briefly. People love that line until they start thinking about it. If, in fact, the Constitution is colorblind and Harlan's right, then affirmative action is in a tougher spot. And in fact, critics of affirmative action are routinely citing Harlan to say we can't consider race for beneficial use, as we call it, as opposed to harmful use. We'll come back to this when we do affirmative action in about 2 weeks or so. Okay? Harlan also said that the legislature is not competent to even enact such a law. It's not within the legislative power. But Harlan was a lone dissenter. He was a lone dissenter in civil rights cases. He was a lone dissenter in Plessy. Think again of Justice Chase as a lone dissenter in Bradwell. You have a lot of these 8-1 decisions, which I think are significant. The fact that there was even one dissenter alive suggests that not everyone saw it the same way, right? When you have a 9-0 case, like, okay, I guess everyone agrees. But even an 8-1 decision can have a lot of power. And I think we'll study some of them this semester when an 8-1 decision has a lot of salience. Okay. Questions on Plessy? I'll summarize a bit. Yes, sir. Please.
Is there any law that contains a purely arbitrary element?
Okay, so I think your question is there any law that's purely arbitrary?
Yeah, right.
If you would ask me and Randy, we would say that a law that's arbitrary is not a law at all, right? That the very definition of law or due process of law is there has to be some justification, some reason. You know, imagine a law that says, you know, every year we'll flip a coin, whoever gets tails gets killed. That's the law. Or I'll give you better. A judge decides a case by flipping a coin. Heads, you're guilty. Tails, remember Two-Face in the Batman, right? Heads, you're guilty. Tails, you die. It's a law. That's what the law says. Is there any reason to it? No. Is that a law? I don't think it is. Right? So Randy and I would say that such an arbitrary law is not really law at all. That it's just fiat. It's like a king issuing a decree. It doesn't have any substance to it.
So was the court objectively stopping any state for enacting a law that's purely arbitrary?
Okay. So our next topic, we start, I think, in about a week or so, considers, actually, do we do Lochner on Thursday? Is due process clause starting Thursday? Yeah, okay, so good. So reading for Thursday, we do case involving Lochner, right? These are laws that the court says are completely irrational. So for example, New York limited how many hours bakers could work. And the court said it's completely irrational. Why would the state care how many hours bakers could work? Now, we can argue whether that's in fact irrational or not. It's not like flipping a coin and murdering the guy who gets tails. But the next round of cases focus on that element that Afosa mentioned. Laws, they say, are completely irrational. Now, the majority of dissent don't agree on whether it's irrational, but that's a good question. That's why I think Yick Wo is easier to understand when you look at the sort of property cases from the early 20th century. It makes a little more sense to me. All right, let me summarize a bit, and then we can wrap up. The Plessy case was the Supreme Court's last major civil rights decision before the 1950s, right? After Plessy, the court more or less turned away various challenges to Jim Crow. They either found ways to uphold them, or they found ways to sort of sidestep them and not really resolve the issue. There are a couple outliers, but there are not many outliers. Plessy, Slaughterhouse, Cruikshank, they all weakened the 14th Amendment. Now, Slaughterhouse, Cruikshank, and civil rights cases are actually still good law. They've never been overruled, which is remarkable. Plessy is no longer good law. Justice Harlan predicted that Plessy would become as pernicious as Dred Scott. He was right. And today, Plessy and Dred Scott are part of the anti-canon. Now, we will study Brown in about 2 or 3 weeks. Brown versus Board did not overrule Plessy in its entirety, but undermined it and said Plessy has no place in public education. One fun fact, or maybe fun's the wrong word, but today there's a group called the Plessy and Ferguson Foundation. Phoebe Ferguson, who I think she's in New Orleans, and Keith Plessy are descendants of the famous litigants. And they found an organization to explain why the case is relevant. Keith Plessy emails me from time to time, which is kind of cool. He found my blog somehow, I don't know how, and he was asking me questions about the case, which is it's kind of cool. He seems like a nice guy. Okay. Questions? No? All right, I'll see you on Thursday. Thank you so much. Yes, sir.
So I was here, but I just spaced out and did.
Can you send me an email, please? I'll fix it later. Thank you so much.